Topic. I'm going to introduce two of our Board of Governors for the Missouri Bar here that have helped contact Judge Dierker and going to handle it from here. Jen Matthews, who was at the Circuit Attorney's Office in St. Louis for a long time. She just changed jobs. Are you with Gretchen Myers, right? Which is a great law firm, plaintiff's PI law firm in Clayton here. Gretchen's a great lawyer, so is Jen, so it's going to be a good match. And we have Joan Schwartz, who has spoken here before. She's also on the Board of Governors for Missouri, and there's Joan right there in the blue. So you can say hi to them, ask them questions, all very good people. Also on the committee, and I'm going to turn over to you, Jen.
So it's my pleasure to introduce Judge Dierker to all of you. His name is Robert Dierker, and I had to learn what year he was appointed to the circuit bench. I looked it up. It was 1986. So he's been a judge for just a few years. Not as long as I've been alive, though. You might have thought that. I'm older than that. No. It's been my pleasure, as Nancy mentioned. I've practiced in front of Judge Dierker for many years in the city in the 22nd Judicial Circuit. By way of background, he is by far and away one of the best judges, I think, in the city. I know you're the only one here as I say that, but...
You're not saying that because I'm going to be the motion judge next year.
No, and I'm not doing the criminal docket any longer. But no, in all seriousness, he literally wrote the book on criminal law and criminal procedure. So attorneys like myself, coming out of law school and even much more seasoned than that, when we're looking for guidance, we literally call it the Dierker book. So I'm not kidding when I say that. He wrote the book. So it is a pleasure to have him here this evening, and I hope that you all enjoy what he has to say. Thank you, Judge.
Thank you. Good evening. I'd forgotten where Jan had gone to work. She had been a stalwart prosecutor for a few years in the city, and I don't think I've had the pleasure of having her try a case in front of me for a while, but this year I haven't gotten a whole lot of trials at all. It's been shocking, but sometimes it happens that way. Is this working, or do you want me to use that?
Good. Keep going.
Are we okay? Lawyers and technology don't always mix, and judges and technology, it's even worse. So I, as Jen indicated, I've been on the bench since 1986. I was appointed by John Ashcroft, and I was informed, actually the entire Judicial College was informed last year that I am now the longest serving sitting circuit judge in the state. So well, the only reason I mention that is that, I've been around too long. So I was intrigued when I was invited to give this lecture because I've never had an experience practicing or judging without the Miranda case being enforced. And as you know from the materials, I suppose, we're in our 50th anniversary of the Miranda decision. And owing to my technological ineptitude, I was not able to prepare, something for the screen. The internet is wonderful, though. I was able to find a picture of Ernesto Miranda. And, when I try criminal cases, if the prosecutor wants to put in the mugshot of the defendant, I almost always let it in because I want the jury to see how the defendant really looks as opposed to how he looks in the courtroom, freshly scrubbed and with his Scott Rosenblum suit on. So Mr. Miranda, as defendants go, he looks relatively harmless. But he did have a propensity for kidnapping, rape, and assault. And he was arrested and interrogated, and in the due process of time and law, he arrived at the Supreme Court. And that was in the heyday of the Warren Court, which, some of you may recall. That was a big deal when I was getting into law, even when I started law school in the 70s. The Warren Court was the epitome of the activist judiciary. And the opinions, for the first time in preparation for this address, I actually sat down and read the entire Miranda case, Supreme Court opinions, and there were multiple opinions. And I think the total is about 120 pages. And what I had forgotten, because in law school we just read, edited chunks of cases that the casebook author thinks is the important part of the case. So I never really read all of it. And so I did, and what was particularly intriguing to me was that it was a 5-4 decision, and the Chief Justice wrote the majority opinion, but what was intriguing to me was that among the dissenters was Byron Whizzer White, who had been appointed by John Kennedy. So it surprised me that Warren was not able to persuade the most recent appointee of a Democratic president to join the majority. And indeed, Justice White's dissent was very trenchant. But the topic that was announced was civil liberties and Miranda at 50. And to my mind, Miranda is criminal procedure, not exactly civil liberties. It's not exactly picketing or free speech or freedom of religion. It's a procedural thing. But to give you a little background on Miranda, if you haven't done any Wikipedia research, as I indicated, he had been arrested, he was charged, he was interrogated, the police had kept him, I believe, standing up for about 4 hours while they interrogated him, and they used a variety of techniques to soften him up. No waterboarding or anything, but they confronted him with people who they said were going to rat him out, and so he ultimately confessed. And there were no warnings given, and he certainly was not offered the opportunity to consult with counsel. So when the case, Miranda was one of, I think, 4 cases on the same issue that were taken and decided together. There was Arizona, Miranda was a lead case, but there was one from New York, and there were a couple other cases. I don't remember the other states. And so Chief Justice Warren, in a very elegant opinion, made up the Miranda Rule. Because, as the dissent pointed out, there's really no basis in the Constitution itself for this rule. This was a rule that was devised by 5 members of the Supreme Court to do what they thought was the best way to protect criminal defendants and arrestees from being worn down, being basically induced to confess without any knowledge of their rights or any opportunity to consult with counsel. Now, the irony of the Miranda decision, and Miranda, we've all seen it on TV. It's, most people can recite it from memory. And you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford an attorney, one will be appointed to represent you, and you may have the attorney with you during all questioning. And you may exercise these rights at any time and stop answering questions, and we have to quit. That's my paraphrase. That's not an identical word for word of what the opinion said. But the Miranda warnings, every police officer, in my experience, has a card, a cheat sheet with the Miranda warnings printed on it, and at least when they're testifying in court, they all pull it out and say, this is what I read to the defendant. And those cards, the language on those cards is lifted literally from Chief Justice Warren's opinion. So the Supreme Court, that was one of the criticisms of the dissent, was, well, you're just making these rules up, and what makes you think this is really going to do any good? And the particular irony pointed out by the dissenters was, you are saying that a confession cannot be admitted into evidence unless the defendant is warned of his right to remain silent and is advised of his right to have an attorney present. but you're at the same time saying the defendant can waive those rights, give them up, voluntarily decide to go ahead and speak without invoking his rights. Why is that less why is the waiver going to be less coerced than the confession that's given without a warning? And I don't think the Chief Justice ever really directly answered that. Suffice it to say that in the aftermath of Miranda, there was tremendous debate, and the dissents as well as the post-opinion criticisms predicted horrific impact on law enforcement. It really didn't happen. And I certainly can tell you, and I'm sure Ms. Matthew would agree, that the police adapted to the new regime. And what we have now is we've gone from a rule which was that a statement of a defendant could not be admitted into evidence unless it was found to be voluntary, to a statement of the defendant cannot be introduced into evidence unless we can find that he voluntarily waived his Miranda rights and spoke to the police. So every criminal case where the defendant has given a statement to the police, typically the defense will raise an objection to that statement. And the way that's done in criminal procedure, and lawyers, I'm sure you all appreciate, we thrive on rules. And we have lots of rules. And since Miranda, we have developed all kinds of other rules, not only for deciding whether a statement can be admitted into evidence, but also for deciding how you're supposed to raise the objection and for deciding when Miranda doesn't apply anyway. And so the regime that we function under now, post-Miranda, is fairly simple to state, but as you will see, it can get a little involved in practice. The statement, the defense will object to it by filing what we call a motion to suppress, to exclude evidence of the statement. Before I get into the minutiae, let me go back to history for a minute. Mr. Miranda did not walk out the courthouse door a free man. The case in the U.S. Supreme Court was sent back. It finally got back to the Arizona trial court, and I feel for the poor trial judge who got that puppy back to have to try it. And I read the opinion that was handed down by the Arizona Supreme Court after he was convicted all over again, without the statement, because the victim identified him and the jury believed the victim. And for good measure, Arizona also tried him for another kidnapping robbery, which had occurred approximately the same time as the kidnapping and sexual assault that was the subject of the Miranda case, the Supreme Court case. And he was also convicted in that case without the admission of a statement. The victim there also identified him, and there was considerable circumstantial evidence. And that conviction was affirmed about 5 or 6 years after the U.S. Supreme Court had decided the first case. So Mr. Miranda, I didn't make a note of just how much time he got, but one interesting sidelight was that when the case went back, the original Miranda case, the trial was with a sequestered jury, and the Supreme Court of Arizona's opinion says that the trial took 8 days. Only half a day was testimony about the actual crime. The other 7.5 days were spent wrangling about still his Fifth Amendment issues. So I can only hope the jury was not sequestered for 8 days for a half a day's worth of testimony. I have a feeling if they had been, they might have mutinied. But so with regard to Mr. Miranda, while he has gone down in legal history, he also went down for multiple consecutive sentences, and I don't know if he ever got out of prison. So to get back to the procedure, which may or may not be fascinating to you, just to give you an idea of how it works, and it's kind of inside baseball, but we get this motion to suppress, and we are required by the rules of procedure to hear that separately. Because if the statement is not to be admitted into evidence, the jury can't hear it, so you can't really take this issue up in front of the jury. So we have a separate hearing at which typically the police officer, the arresting officer, the interrogating officer will testify. Sometimes the defendant will testify. On very rare occasions, you might have a civilian witness, but that's extremely rare because most interrogations obviously occur while the defendant is in custody. So we deal with the motion to suppress. If the trial judge believes that the warnings were given, that the defendant understood them and agreed voluntarily to give them up and talk to the police, then the statement can come in to evidence. And if the trial judge does not believe that, then the statement stays out, unless the defendant chooses to testify at trial and give a story that is dramatically different than what he gave the police, which has been known to happen. And in that case, here's one of the first rules about getting around Miranda. If the defendant chooses to tell a story to the jury and has told a different story to the police, even if it was otherwise inadmissible under Miranda, it can come into evidence in rebuttal if the court finds it was voluntary. And the giving or non-giving of the Miranda rights is not decisive in that situation. So it's only strict, we're back to the voluntariness standard, which was the standard of the law exclusively until the Miranda decision. So if any of you have had the pleasure of serving on jury duty and you've heard or had the pleasure of seeing a video of a defendant emoting about the crime, that only got to you because the lawyers and the judge had done preliminary work to decide that it could be admitted into evidence. Now, I think the simple part of Miranda I've just described. Now, where we get into the nuances, the exceptions, the qualifications. The first major issue is, do the warnings have to be given at all? And the warnings do not have to be given unless the defendant is in custody. And then we get into a big wrangle about what is in custody. And many police officers have a conception, and I think, and rightly so, they have to function within certain field orders, procedures that are prescribed by their superiors with, sometimes I'm sure the city police hierarchy would consult the circuit attorney, and sometimes I'm sure they don't. But in any event, the police officers have their procedures, and they have certain concepts of what they think is happening. And many police officers, in my experience, will have a defendant, they've apprehended him, and he's in handcuffs, and they'll say, well, the question will be asked, was he under arrest? Well, no. And, well, to me, if you're in handcuffs, you're under arrest, generally speaking. But lawyers being lawyers, we have refined this definition of what is or is not custody. But suffice it to say that while the police officers have kind of a formalistic idea that it's almost British, until you've been touched on the shoulder and said you are under arrest, you're not under arrest as far as they're concerned. As far as I'm concerned, once in the courts, the law is that once your freedom of movement has been restrained in a significant way, you are in custody. But we get into a lot of wrangles about whether somebody is in custody or isn't in custody. When police are executing a search warrant, for example, and they don't want people wandering around the house, they shove them off in a corner somewhere. Well, are they in custody? Well, they're not free to leave. So you can get into a debate over whether if the police decide to interview them, do they need to give the warnings or not? So that's the first issue. Then, of course, the basics, did they give the warnings the way they're supposed to? And did they get a waiver? Now, the next question will come up is, well, the defendant was in a hospital bed, he was just come out of surgery, and the police are descending on him, and he doesn't know, he's still doped up, and he doesn't know what he's doing, so how can he voluntarily waive anything? And the courts have addressed that in a variety of contexts, but the fundamental purpose of Miranda is to minimize, deter, ideally prevent coercion. So if there's a situation that's outside the police officer's making or control, generally speaking, that does not affect the voluntariness of a waiver, as long as it's the defendant making this decision, even if he's doped up or even if he's mentally ill. The key factor is police coercion. And so that's another nuance where we get into, can we put the statement in, the warnings were given, were they waived? Another favorite issue that can crop up is, did the defendant properly invoke his Miranda rights? We can get into situations where the defendant, in response to the always invariably polite warnings from the police, will respond with an expletive and says he doesn't want to talk. Well, that may or may not be an invocation of his Miranda rights. And so the Supreme Court has said that the invocation of Miranda rights, and particularly of the right to counsel, has to be clear, so that the average police officer clearly understands that he's invoking his constitutional rights. So you'll get these situations where there's some palaver going on, and the defendant ultimately just decides, fine, I did it, And I happened to find my aborted visual aid here was a cartoon with the police officer reading to the defendant, "You have the right to remain silent," sort of. I mean, we're kind of in the middle of a big national debate on this. As a society that values freedom, it's quite a balancing act. Even Obama has waffled on the topic. So I'm stuck between the philosophical politics of it all and just plain keeping people safe the best way I can without infringing on their rights. The defendant, "All right already, I'll talk." So we get those kinds of situations. Now and then to go back to the custody issue, how about a traffic stop? Are you in custody? Well, I don't know about you, but when I was stopped by one of Shrewsbury's finest a couple of years ago, because I'd completely forgotten to renew my license plates, and so my license plate was out of date. But I thought I may have been going a little too fast, but in any event, when he stopped me, I kept my hands on the steering wheel, and I was not about to leave. And so, the idea that you're free to leave or that your freedom of movement has been restrained, quite clearly you've stopped and you're not going to leave. However, the Supreme Court has said that is not, generally speaking, custodial interrogation. A routine traffic stop with the routine discussion is so commonplace that nobody should feel, terrified by that kind of an encounter or need to be given Miranda warnings. And then we also get, suppose there's a break in custody. You're arrested, you're released, and then the police go out to visit you at your house and seek your assistance in incriminating yourself. How about that situation? Well, there are other rules governing breaks in custody, and when do we have to give the warnings again? Generally speaking, though, if you're being interviewed in your home and there's no real reason to believe that you're not free to say to the officer politely, of course, would you mind leaving? I have to go to the bathroom. Then the warnings don't necessarily have to be given. Many officers, I think, do it just to be safe. There are a lot of officers out there who would rather just go ahead and give the warnings because, in their experience, they know that most defendants, rather foolishly, are willing to talk to them. And the problem with the defendants doing that is, of course, they may think they're being clever and they'll give this airtight story to the police, and then it'll start breaking down because the police know things that the defendant doesn't know they know. And it's so usually the decision to talk to the police is not a good one. And some defense lawyers have their business cards printed with, on the back of the business card, they have it in very simple terms. If you want to walk, don't talk. And I
Still don't listen though.
what's that?
Yeah. Still don't listen though.
Well, they still don't get it, and so we have these situations where we're continually faced with these variations, and all of these situations are a result of the system reacting to Miranda. Every rule of law, lawyers, this is what they do. They look for a way to get around it, and or they look for a way to expand it. Ms. Matthew has now become a plaintiff's lawyer, so she's going to want to be able to sue anybody for anything at any time. But if any of you out here work for an insurance company, you'll know that you don't want to pay for anything to anybody at any time. So there's this constant, so the insurance company lawyers are going to be trying to straitjacket Ms. Matthew, and Ms. Matthew is going to be trying to burst out of that straitjacket. And so the same thing goes with the practice under Miranda. And so we get this series of cases. Now, an interesting sidelight on Miranda was that shortly after Miranda came down, Congress bestirred itself and enacted a statute that said, you don't need warnings. As far as we're concerned, the only issue is the statement voluntary. So the statute said that a statement of a defendant is admissible if the court finds that it is voluntary. So the Congress basically attempted to nullify Miranda. Nobody paid any attention to that statute for years. I think it was enacted in 67 or probably 68 when, as some of you who may be of my era remember that we had the Safe Streets Act of 1968. We had tremendous developing law and order mentality, and 68 was a very rough year. So Congress passed the statute, and it was ignored until around 2000, when a federal court of appeals said, well, wait a minute, here's this statute. Miranda is just a rule that the Supreme Court created. It's not really a constitutional provision. So Congress can legislate it away and say, no, voluntary, because the Constitution, and I don't want to get into the whole esoteric thing about there's something called incorporation, where the courts have said that the Bill of Rights, the first 10 amendments of the Constitution, some of them are applied to the states because of the 14th Amendment, which was adopted after the Civil War. And so the 14th Amendment says Congress shall have the right to enforce this article by appropriate legislation. So the Court of Appeals, and I think it was the Fourth Circuit in Virginia, said Congress can annul the Miranda Rule because it's not really part of the Constitution, and Congress has the right to enforce the 14th Amendment. So if Congress says, this is how we're going to enforce it, then that's how we're going to enforce it. So the Fourth Circuit basically said Miranda is no longer good law. So that went to the U.S. Supreme Court, and I excerpted. And by the way, the materials that you were given, I thought it might be interesting. I knew it would be more interesting than any outline that I put together. There is an excerpt from my book in there specifically about Miranda, so you'll see how exciting that can be. But I thought that excerpts from some of the major opinions would be the best to give you the flavor of what the courts do in their own words. And so I put an excerpt from Justice Scalia's dissent in the Dickerson case, which is the case that went to the U.S. Supreme Court on the issue of the statute that purported to annul Miranda. And I believe that only Justice Scalia of sainted memory and Clarence Thomas agreed with the Fourth Circuit. Chief Justice Rehnquist, who was not considered a liberal by any means, said, well, it's been around now for all these years and everybody's used to it, and we're not going to, it's not a bad thing, so we'll keep it. And Scalia, with his usual trenchant analysis, said, yes, yeah, we're going to keep it, not because it's in the Constitution, but because you don't want to get rid of it. And this has nothing to do with the Constitution. But suffice it to say, the Supreme Court functionally has said, yeah, it's part of the Constitution, so get used to it. And we were and are. And as I said, it has not. I think it certainly has an effect, it is important, and it is probably certainly easier, as it turned out. All of the doomsayers about the effect on law enforcement, were, they hit the panic button unnecessarily, because the Miranda Rights, as I've indicated, most of the time the defendants just go ahead and they may lie, but they were probably going to do that anyway, and so I don't think it has had the impact that was forecast by the dissents or by the critics afterwards. As I said, the system has adapted to it. And so Dickerson said, we're going to keep Miranda, and nobody has seriously questioned it. But of course, under Chief Justice Rehnquist and subsequently, the court continues to kind of nibble away at the application of it, so that they kind of keep it narrowed down to pretty much the classic situation where the defendant is arrested, is taken to the police station, and is going to be interrogated, and he gets the warnings. Now, I had a case a number of years ago. There was a suspected serial killer in the city who was arrested, and somehow word filtered out of headquarters that he had asked for a lawyer. And the public defender's office came running over, and they came to me because I happen to be in what we call our equity divisions. And when I apologize, because it's almost impossible for me to talk about anything that goes on without getting tangled up in procedure. But I'll try to. My daughter, who's a third year at Washington University Law School, keeps chewing me out for not being clear. So I'm trying to be clear and not make it harder than it has to be. The bottom line is the case. The public defenders come running over to me and say, Mr. So-and-so, we understand he's demanded a lawyer, and the police are not letting us talk to him. And the usual response of a judge in that situation is, what do you want me to do about it? But I was perhaps an activist. I don't know, God forbid. But there's a remedy for that situation. Under Missouri law, someone can be arrested and detained for up to 24 hours before a judicial warrant has to be obtained, or the person has to be released. So the police were hoping to, at that time it was 20 hours, they were hoping to have 20 hours with a post-Miranda discussion with this guy. But the public defenders came over, and I said, well, you're supposed to be defense lawyers. have you heard of the writ of habeas corpus? You know, so, so they filed for a habeas, and I duly issued it. It was served, and lo and behold, the body of the arrestee was produced in my courtroom, and I told him, you know, what his rights were, and I told him, if you want a lawyer, you're the public defender, they're ready and eager to represent you. And if I remember correctly, he did say he did want a lawyer, and so that put a spoke in the interrogation wheel. However, the individual subsequently committed suicide, so we never really found out if there was a lot of evidence that came to light later that the police were probably on the right trail on this guy, and it was something that had he not committed suicide, I'm sure we would have had a very sensational trial similar to the case in Atlanta a number of years ago where they had a serial killer that was preying on black teenagers and preteen boys. And this guy was apparently doing the same thing, both here and on the east side. But I bring that up just to illustrate that there is a mechanism if and this is the big if the arrestee can somehow get the word out. Traditionally you're entitled to one phone call, and actually there is a basis in Missouri law for that the police have to accord you the opportunity to communicate with somebody, at least as I understand the law. So these things can make a difference, and but they have not created the nightmare of thousands of aborted prosecutions and defendants going free. Ernesto didn't accomplish too much. I'm sure that he was gratified to autograph prison menus for his colleagues, but and actually the second case that was tried after it went back down, they tried him under a phony name because they felt everybody in the world knows who Miranda is, so we'll never get a jury if we tell them who he really is. So they tried him as Jose Gomez, and he was still convicted. So now, one thing I also thought I would talk about with regard to cartoons. Well, the horror, the horror story type situation. I found another cartoon which I'm not able to display, but shows a ISIS-like figure in the witness box with the judge, and he's saying, "There I was, driving bin Laden, minding my own business, with a couple of missiles in the trunk, and they never even read me my Miranda rights." And I think we're all familiar with the Tsarnaev situation in Boston, where after the marathon bombing, he was apprehended, and of course he was given his Miranda rights, and I don't think that his lack of a confession, I don't think the lack of a confession seriously harmed the government's case and his situation, but it is something, should there be an exception for, certain kinds of arrestees? I think the Constitution is clear, and I think, this is where Justice Scalia has always, and Justice Thomas also, are very consistent. If it's in the Constitution, it counts. And while the Miranda rights per se are not there, obviously the issue of protection against self-incrimination is there. So I don't think you can just say, okay, go waterboard them to your heart's content. I think Henry versus Mississippi was a case from the 30s where a black man was arrested and literally beaten. A confession was literally beaten out of him, and the Supreme Court said, no, that's not going to work. That's the exact thing that the Fifth Amendment was designed to prevent. And so I think I don't see any basis in the Constitution, any legitimate basis to carve out some exception for a suspected terrorist. Now, one other feature of Miranda, and it ties in with all of the other exceptions and whatnot, is the spontaneous statement, where the police walk up to the defendant, the suspect, and say, "You're under arrest for murder." "It's a fair cop, I did it." Well, the police didn't even have a chance to give him his Miranda rights. Do you let that kind of a statement in? Well, we do. The police are not expected to say, "Well, no, don't," they're not supposed to say, "Don't say anything," before they even have a chance to say, "Don't say anything." And so but that brings me to another facet of Miranda, and this is where Missouri, gets the glory. There was something called the Missouri two-step, which was a technique where the police would interrogate, get the confession, and then they'd give the Miranda warnings and get the confession again. And then they'd say, "We're not going to use the first confession, we're only using the second one." And the U.S. Supreme Court said, no, if I'm not mistaken, I think the Missouri Supreme Court said, no, you can't play that game. Now, a few years before that case came down, I was hearing a motion to suppress, and Ms. Matthew was not the prosecutor, and the detective was testifying, and on cross-examination, the question was, "You didn't read Kim her Miranda rights until an hour after you first met her, is that correct?" Answer: "I read her Miranda rights after she confessed to the crime." Question: "Which was an hour after you met her?" Answer: "Whatever the time frame was. When she admitted to the crime, I read her Miranda rights." You didn't, he asked another question about some other suspects. "Is this typical of your investigation style?" Answer: "Yes, it is." I suppressed that statement. But the officer, I don't think it really dawned on him that I don't think it was a deliberate Missouri two-step plan on his part. It was just, well, she's in custody and we're going to talk, and then when she says something incriminating, then I'll give her Miranda rights. And it seems fair to me, but that didn't work.
Your Honor,
Yes.
in a case like that, is that case then thrown out? Or,
Well, that's a good question. I mean, the answer is in the Miranda case itself. The suppression of a confession does not necessarily terminate the prosecution. Relatively few cases depend, I think Ms. Matthew will agree, relatively few cases depend so heavily on the statement of the defendant that without it, he goes free. But there can be cases where literally the only evidence directly linking the defendant to the offense is his statement. And if his statement goes out the window, the state does not have enough evidence to submit the case to the jury. So that is something that it can happen, but that goes back to what I said about the impact of the Miranda decision itself, is that as Ernesto demonstrates, they were able to convict him in 2 cases without his statement. It would have been nice to have the statement. Now the other thing you get into is what's called the fruit of the poisonous tree, where the police get an incriminating statement. The statement itself is thrown out, but it led them to other evidence that is incriminating. And so then we get into a wrangle about whether that evidence comes in or not. And there are a variety of rules on that I'm not going to bother to get into. Oh, yes, sir.
If the police refuse to get you an attorney, do you have any recourse?
Well, in the immediate context, no, other than just don't say anything, because you have to be taken before a judge not later than 48 hours after the arrest. And in Missouri, you physically are brought before a judge, usually within 24 to 36 hours, I think. Isn't that roughly, almost never more than 48. You know, the police have to, but if you say, no, I want a lawyer, and the police say, well, yeah, well, maybe later, we're not going to give it to you. Your only recourse is to make sure you don't say anything, and then when you get in front of the judge, you know, say, hey, I haven't been allowed to see a lawyer. Now, the other option, potentially, you know, if the thing goes forward, you know, in theory, there's, and this is a whole other lecture in and of itself, which is the liability of police for violating constitutional rights. And so there is a lawsuit that somebody like Ms. Matthew would be happy to bring against the police for, to recover damages, but while you're in the penitentiary, the damages might not be particularly valuable. But no, I mean, it's like the situation I mentioned a little while ago about the guy who was in custody, and somehow the public defender found out he'd asked for a lawyer, and they came over to me. That was a very unusual situation, because when you're in the police custody, you know, unless they give you the one phone call, you know, you're pretty much incommunicado until you're either released or taken, you know, before a judge. Now, I think I'm supposed to break pretty soon, but I do want to give you some, I've been talking a lot about rules, and some of you may have heard of Alan Dershowitz. He's a prof at the Harvard Friendly Law School, and I think one of his more illustrious moments was when he was able to get the conviction of Von Bülow reversed for, Mr. Von Bülow supposedly murdered his wife, and Dershowitz was brought in on the appeal and got the Rhode Island Supreme Court, I think, to reverse it. And I don't remember the exact basis, but I think Von Bülow, he walked in that case. And I'm sure Alan Dershowitz made even more money than he had already made. That's one nice thing about being a Harvard law professor. They're not poor. But Mr. Dershowitz came up with a number of what he considered to be rules, the key rules of the justice game. Rule 1, almost all criminal defendants are, in fact, guilty. Rule 2, all criminal defense lawyers, prosecutors, and judges understand and believe Rule 1. Rule 3, it is easier to convict guilty defendants by violating the Constitution than by complying with it, and in some cases it is impossible to convict guilty defendants without violating the Constitution. Rule 4, almost all police lie about whether they violated the Constitution in order to convict guilty defendants. Rule 5, all prosecutors, judges, and defense lawyers are aware of Rule 4. Rule 6, many prosecutors implicitly encourage police to lie about whether they violated the Constitution in order to convict guilty defendants. Rule 7, all judges are aware of Rule 6. Rule 8, most trial judges pretend to believe police officers who they know are lying. Rule 9, all appellate judges are aware of Rule 8, yet many pretend to believe the trial judges who pretend to believe the lying police officers. Rule 10, most judges disbelieve defendants about whether their constitutional rights have been violated, even if they are telling the truth. Rule 11, most judges and prosecutors would not knowingly convict a defendant who they believe to be innocent of the crime charged or a closely related crime. Rule 12, Rule 11 does not apply to members of organized crime, drug dealers, career criminals, or potential informers. Rule 13, nobody really wants justice. Well, that was Professor Dershowitz's take. Some of those rules, I think, they're accurate. I've been known to quote those to lawyers in front of me. So, but I will say, however, I do not pretend to believe lying police officers. And when we come back from our break, I'll tell you where most police officers lie, and may or may not surprise you. So I think we're supposed to take about a 15-minute break at this point. I didn't really think I could kill a whole hour just talking about Miranda, but I managed to. I just read an article in the Wall Street Journal about how your aging vocal cords, and mine are beginning to age, I guess. So, you had a question, sir?
Yes, Judge. When they say if you can't afford it, a public defender will be appointed, who makes the determination of if you can afford it?
The public defender. No, seriously, that's who. Well, in the first instance, the public defender. If the defendant, if they reject the defendant can come to the court and say, hey, the public defender is trying to avoid work. I'm too poor for a lawyer, and the court has the authority then to insist that the public defender take it. That's all. I may start a harangue on that in a few minutes, but during the break there were several points that were brought up that I'd like to talk about. One was mentioning, was Mr. Miranda an illegal alien, and what's the situation with that kind of an arrestee? The 14th Amendment talks about no state shall deprive any person of life, liberty, or property without due process of law. It refers to person, it doesn't refer to citizens. So the rules, for the most part, if you're in this country and you're arrested, the same rules apply regardless of your citizenship or non-citizenship. And in fact, if you are an illegal alien and you plead guilty, we have to be extra careful that you know that you could be deported, because otherwise the conviction could be overturned because the plea will be considered involuntary. But the whole guilty plea thing is another issue. So aliens, doesn't matter. If you're arrested in this country, our rules apply to you. We have the big issue with the people who are detained at Guantanamo, and there were a number of cases handed down a number of years ago with regard to the authority of the federal courts over those people and just exactly what rights that they have, and I'm not really prepared to discuss that at length. Suffice it to say that the cases that were handed down in the 21st century were at odds with the cases that were handed down in the World War II era, where the Supreme Court took a much narrower view of what, if any, rights an enemy combatant enjoyed. And there were a number of German saboteurs who were apprehended, tried by military commission, and executed in 1942-43. And the U.S. Supreme Court said, perfectly okay. So there's a tension in the law about the enemy combatants, aliens, and the like, but the garden variety criminal case, all the rules are the same. Another question was brought up was about juveniles. And Missouri has a very restrictive law specific to juveniles and interrogating juveniles. And in addition to the Miranda warnings, it's entirely separate, and it's over and above the Miranda warnings. The ability of the police to interrogate juveniles is severely limited. The deputy juvenile officer has to be present. The parents have to be afforded an opportunity to be present, or they get notified. So interrogations of juveniles who are, if you're under 17, you're a juvenile in Missouri. It's very limited. When I was clerking for the Court of Appeals many years ago, I worked for one of the greatest judges who ever sat in Missouri, Joe Simeon, and he sat on a case where two juveniles, they were convicted, so I think I could say they murdered somebody on Halloween who had answered the door thinking he was getting trick-or-treaters, and he was robbed and murdered. And the confessions were the key to the case, and they were thrown out because of the restrictions on interrogating juveniles. And there was a very famous case before that called Arbeiter, where an elderly lady was stabbed to death by a juvenile, and it happened next door to where my godmother lived, so I was kind of close to home. But That case, almost the only evidence linking that defendant to the crime was his statement, and it was thrown out. And I think Mr. Arbeiter, however, like Mr. Miranda, had a propensity, and I think he ultimately ended up in the pan on other charges. But suffice it to say, juvenile interrogations are severely limited. And then another comment was made about the Dershowitz rules and the fact that they do have a kernel of truth, and it's somewhat concerning. And I promised, I think, before we broke, to tell you, in my experience and observation, while there are some, and we've encountered a few in the city of St. Louis, where we did have some actively dirty cops who would plant evidence on defendants and otherwise, frame them. But those are, in my experience and observation, very few and far between. Where the police get in trouble typically, and it is one of Dershowitz's rules, which is that police officers will lie about whether they violated the Constitution, and police officers do have a tendency to try to massage the testimony to fit what they think I want to hear as a judge, what they think the law is. In fact, there was an officer. He's still on the force, so I won't identify him, but he was a lawyer. And his police reports read like a Miranda opinion. And it was kind of amusing. But what I found is that in 9 cases out of 10, if the officers would just tell it like it happened, they're going to be okay. But they get paranoid about, if I say that, will the evidence be thrown out? And this is more true on search and seizure cases than on confession cases. Because on a confession case, really the only issue is, did you give him his warnings and did he agree to talk to you? And most of the time, at least certainly my observation, the officers are not lying about the warnings. And in fact, as I read you that transcript of the testimony from me, that guy was very frank about how he did it, and it was obviously not the right way to do it. And would he do it the same way and then lie about it next time? Well, it depends. Some officers do lie. And we judges usually can identify them because they kind of have an MO and they come up with stories that just don't make a lot of sense. And sometimes the defendants, and I've been around long enough that you can't hear the same thing over and over and over and over again in hundreds of cases and not think, this must be happening. And the police officers will testify that the defendant threw down the drugs in front of the officer. What idiot is going to do that? But everybody keeps saying it, and I've heard enough cases, and I've talked to some defendants after the plea is over, and and I've just asked them point blank, what really happened. And they say, well, yeah, I didn't want to be caught with the heroin on me. There's a pervasive view in the amongst the retail pharmaceutical trade, street corner pharmaceutical trade, that if you are not, if you get the drugs off of your person, you're much better off. So there's a lot of, so the throwdowns, I think, really do happen. But likewise, I think it also very frequently happens that the police will roll up on a group on the street, and they'll cuff some people before they really have the probable cause that they ought to have. But there too, 9 times out of 10, the individual is on probation or has a warrant, and the instinct of the police officer was valid. Now, was he going by the rules? Well, no, not really. But that's where while in a perfect world, we wouldn't have this happening. But just as the defendants sometimes will say anything to get out from under, sometimes the police are going to say anything because they're convinced that the defendant is guilty and they don't want him to get away with it. And that's what that's the hard part of my job, is trying to sift out what really happened from what people are telling me happened. And after a while, I think I And the adversary system really does work. I mean, the system we've got, I've watched this now. I don't pretend that I was a great trial lawyer. I did most of my work in non-jury contexts and in appellate courts, but the adversary system really does work. Both sides, are contending and throwing their best case out, and we don't always get the whole truth, and we may not get the exact truth, but we get a pretty good approximation of what really happened. And when you sit on a jury and you see this, I think you get a pretty good picture of what really happened, and you get the ability to make a good judgment on it. So I think I've addressed the issues. Yes, sir.
Yeah, you mentioned search and seizure. Do you have to give permission to somebody to go into your house or to go into your car? Is that covered then as something that unless you say, yeah, you can have it? Obviously, they get a warrant or something. But I mean,
Well, the law, and this is also another lecture in and of itself. But no, the general rule of law going back, to England, and one of the big issues in the Revolution was the ability of officers to, break into your home and, search and seize. And the law has been since certainly at least the 18th century is that officers have no right to do that unless they have a warrant. Now the courts, we've come up with all kinds of exceptions where, if they're in hot pursuit, if you're running away from, just committed the bank robbery and the cops are after you and you run into your house, they can go in after you. They don't have to stop and wait and get a warrant. But the big debate, and when I was in law school and in the 80s, was what we call the exclusionary rule, which is a rule that the Supreme Court came up with, and this predates the Warren Court, so I'm not, this goes back to the even pre-New Deal era. It's called the exclusionary rule, which is the way we enforce the warrant requirement. If the police don't have a warrant and can't demonstrate an exception, the evidence gets thrown out. And in theory, that deters the police from violating your rights because they know it's not going to do them any good. There's a big debate about that because the exclusionary rule itself is really, it's like the Miranda Rights. It's not in the text of the Constitution. And the common law was that without a warrant, the police officer is liable in damages for doing what he did. And there was no, if he didn't have a warrant, that's the end of it. He's liable. It's trespass. And that was considered to be the remedy. Now, practically speaking, if somebody gets caught with drugs and there's a violation of the warrant requirement, a lawsuit, is not going to be very productive, and might help him buy more cigarettes in the penitentiary. But there is a valid argument that the exclusionary rule does more harm than good because it does let manifestly guilty people go free. But that's another area. I could also tell you about the case I had in the U.S. Supreme Court involving police officers who were executing a search warrant and they were gunned down by Willie McCurry, and then he sued them for violating his rights. And I got involved in the case. The state court convicted him, said the search was legal, and he sued in federal court. One of the officers held in damages, and we said, well, the state court said that it was legal, so that binds the federal court. Well, the lower federal court said, no, it doesn't. We have a right, we're going to decide it for ourselves. We got the U.S. Supreme Court to take it, and we won 6-3. The Supreme Court said, no, if the state court has litigated this fully and fairly, that's the end of it. And so Mr. McCurry did not collect anything. Unfortunately, Officer Allen, this didn't come up at oral argument in the U.S. Supreme Court, but in the interim, Officer Allen had gotten addicted to heroin himself and turned to robbery to feed his habit. And shortly after I went on the bench, he appeared in front of me to plead guilty to an offense, and I said, "You're Marvin Allen? I've represented you in the Supreme Court." And it was a very sad, very, very sad situation for him. And But anyway, that's a war story. I guess I ought to talk about civil liberties. I don't want it to degenerate into war stories here. Yes, sir.
The search and seizure go to automobiles?
Automobiles are an exception. In general, the police can, if they have probable cause, if they have reasonable grounds to believe that the automobile contains contraband or evidence of a crime, generally speaking, they can search an automobile without a warrant. There are exceptions to that where they do have to get a warrant if the automobile is impounded for other reasons and they don't have probable cause to search it immediately, then they could be required to get a warrant later. There are situations where a warrant is required for an automobile, but there's a general, back in the Prohibition days, the U.S. Supreme Court said, automobiles are mobile, they can get away. So the officer really can't be expected to get a warrant. So we're going to let them be searched. And I think they dredged up some English common law cases on searching ox carts and wagons, and it was okay. But I did include some stuff on the First and Second Amendments. I tried to pick out some of the more famous quotes, like Oliver Wendell Holmes on the clear and present danger and fire in the crowded theater kind of thing on the First Amendment. And, that whole area is, very involved, and I don't think anybody is able to state a very coherent rule on what does and what does not violate the First Amendment. Flag burning is protected, cross burning is not. You can wear a jacket in a courthouse that says F the draft, but at least the city of St. Paul tried to outlaw, quote, hate speech, unquote, and but the Supreme Court said you can't do that, you can't outlaw that, at least the way they did it. So it's a very involved thing. I included some quotations from Justice Story, who was John Marshall's right-hand man in the early era of the Supreme Court of the United States. He was a very prominent judge and scholar, and he was on the Supreme Court a very long time and was an authority on the Constitution, and he was a Federalist, even though he came from Virginia originally, I believe. There's a big statue of him in the Harvard Law School main building because he was a prof there for many years. So I thought I'd throw in some quotes from his commentaries on the Constitution to give you an idea of what judges in the early 19th century thought the Constitution meant. The Second Amendment, obviously we've had a lot of recent litigation about that, and the U.S. Supreme Court did hold that it was the right to keep and bear arms is fundamental, and in so holding, they then went the next step and said it applies to the states, and so we're now dealing with the sequels to that as to, well, just how far does that go? Are we going to treat it like the right to free speech, which imports a lot of limitations and restrictions, or are we going to treat it like the right of property, which is kind of like, well, if you've got a good enough reason, the government can, regulate your land so that you can't use it. The guy would, well, that's another lecture too on property rights, but to suffice it to say that the litigation on the scope of the right to keep and bear arms is continuing. I think that many regulations that effectively prevent people from having arms in their homes, at least, are not going to survive. As you know, in the wisdom of our legislature, they have pretty much the statute that they passed on open carry, concealed carry, is very long and involved, and I've read it a couple of times, and I'm not sure I completely understand it, but I think as a general proposition, we can carry our guns concealed almost anywhere with or without a permit. There is a laundry list of exceptions to places where you can't do that. But if you violate that, if you carry a weapon into a school, for example, I believe it is now a Class B misdemeanor, which is a maximum of 6 months in the local jail. So the concealed weapons law in Missouri has been drastically revamped to the point where, I think how many of you have seen the movie Hell or High Water? I see a few people. It's about these bank robbers, and the climactic bank robbery. They go in, and it degenerates into a gunfire. Every customer in the bank opens fire. And that's in Texas, but I think we could be heading in that direction. I hope not, and I'm not sure that it's going to be quite as insane as most alarmists feel about it. But clearly, that's kind of an outgrowth of the Second Amendment decisions of the U.S. Supreme Court, and will those decisions be overturned if the court composition changes? I'm not so sure. I think that but as with Miranda and as with many other decisions, once again, lawyers and judges are going to be looking at, well, if we don't want to throw this out, then how do we limit it? And so I would anticipate that if the composition of the Supreme Court, it's going to change, because we have the one vacancy. And, I would anticipate that we'll be in a situation very similar to Miranda, where the scope of the federal constitutional right to keep and bear arms will be narrowed, made subject to exceptions, and the ability of the states to regulate will be enhanced. But I would be somewhat surprised if, even with a change in the composition of the court, that they would just overrule Heller. Yes, Joan?
Judge, the question I have is similar to what you just posed. Do you think the change in the Supreme Court will affect Miranda now that we're 15 years down the road and there is, shall we say, robust case law around the rights attended to Miranda?
Well, I don't think so, because I think the Dickerson decision, which I mentioned before, which dealt with that congressional statute, that was, you had the so-called Rehnquist court, so in theory, if you kind of have a feeling that the, quote, conservative justices are in lockstep, that would have been the time to get rid of Miranda, and they didn't do it. And I can't imagine, with the likeliest, with the likelihood of who's going to be making the appointments in the next 4 years, I can't imagine that there will be any significant effect on the Miranda principles or an application. There might be a little tightening up in terms of enforcing them instead of creating new exceptions. I can't offhand think of any clever new idea that the prosecutors have come up with for limiting or narrowing it. I think the exceptions to Miranda have been, very much a product of the circumstances of particular situations where the Supreme Court was unwilling to say that that the game was worth the candle, that we should throw this statement out because if we don't, we're undermining the Fifth Amendment privilege. I think they look at these things like the spontaneous statements or the break in custody. You would think there was a case that came down where a defendant was in the penitentiary, which seems like you're in custody. And he was brought to an interview cell and was interrogated, and the the Supreme Court said, well, yeah, he's in the pen, but he wasn't really in the custody of these officers because he could have said, no, I don't want to talk to you, and gone back to his general population, gone back to the yard. And so, okay, the fact they didn't give him Miranda warnings, that's okay. And then, the right to counsel, which is mentioned in Miranda, there are two aspects. There's the Miranda feature of right to counsel, where you have a right to have an attorney present during interrogation. Well, there's another right under the Sixth Amendment, which is the general right of counsel to assist in your defense. And that right has always been thought to attach as soon as you're formally charged with a crime. And so then you have a right to an attorney. And for a long time, there was a very bright line rule that once you were formally charged and had the right to an attorney, you could not be interrogated at all without that attorney present. The Supreme Court has recently retreated from that, or I should say they've fogged up the bright line. And they've said that if the defendant is given his Miranda rights and warnings, and he chooses to talk anyway, that it does not violate the Sixth Amendment right to counsel if it's otherwise voluntary. And so that's a big change, although typically, once it gets to the point where the defendant's actually subject to a formal charge, most defendants have, the innate common sense that maybe I better not talk to anybody. Now, what can happen and does happen is that, and I've had it happen, in the holding cell behind my division, where we've got a defendant on trial and the police want to talk to him about a different case. And so they do. And sometimes I know about it, sometimes I don't, because I'm not watching holding cell, I'm usually doing something else. And so I've had that situation, and of course the defense attorneys go ballistic. How dare they interrogate my client? And the law is pretty clear that if it's an unrelated case and they give him the Miranda rights, then that's okay. Obviously, he's certainly in custody, and they have to give him the Miranda rights because that, notwithstanding the prison yard situation, I think in that context, when you're in a holding cell, I think you're pretty much in custody.
And for everyone here, I think the materials are in the book, are they? That
Yes.
Judge Dierker prepared? Yeah.
Mm-hmm.
Because.
I don't think you have Alan Dershowitz's rules, but.
No, but the color isn't in there, but that's from your book, much of the materials, right, Judge?
I do have an excerpt in there from my criminal practice handbook on Miranda and custodial interrogation rules, and it may be a little, I won't pretend to say it reads like a novel. Reads like something a lawyer would write.
Right, but it's readable. I read it sitting here. I don't do criminal law. I do civil law, so this isn't my area of practice, but for the reason I'm bringing it up is many of these issues are raised in what the judge has in this handbook, which is a very good reference materials that lawyers who do this use to find the right cases when things come up. And make sure they know updates in the law. But that is the law in Missouri, which may, and state to state, are there differences on Miranda, or are there really not, is that not a true statement?
Well, Miranda being a federal rule binds all the state courts. So insofar as Miranda is concerned, we all, in theory at least, are marching to the same drummer. Now, I mentioned the juvenile interrogation rules in Missouri. Those are specific to Missouri. Other states may have different rules. So anything that doesn't relate, the states are free to impose more stringent rules than the Miranda rule. They cannot impose less. So the Miranda is is basically the floor. And the state legislature, the state courts are free to go beyond Miranda if they want to. And some states, I haven't made a study of what the other states do. It's all I can do to keep up with Missouri and the feds. But I do know from reading federal cases that, and sometimes when there's an issue that crops up that hasn't been decided by a Missouri court, we'll look at other states to see how they've handled it. I would like to go back to the Second Amendment for a minute because just tell it's a story that I don't think reflects any credit on me necessarily, but the Missouri voters adopted a constitutional amendment to the Missouri Constitution that revised the Missouri right to keep and bear arms. And the issue cropped up as to whether that protected a convicted felon who was in possession of a firearm. Because there is a blanket, in Missouri, there is a blanket prohibition on a convicted felon possessing firearms. And this constitutional amendment provided that the right to keep and bear arms is fundamental. Any regulation is subject to strict scrutiny. And strict scrutiny, that's a magic phrase that comes out of federal constitutional law on fundamental rights, First Amendment, speech and religion primarily, and racial discrimination situations. I said that the blanket prohibition on a convicted felon having a weapon was unconstitutional. I said he could have it. This particular defendant, because he had no record of violence, and I felt you had to narrowly construe the prohibition. The Supreme Court of Missouri said, no, it survives strict scrutiny, it's okay, the blanket prohibition stands. And so that's fine, but we've got several cases that have come up where the police were called to a home for some kind of domestic disturbance or whatnot, and they found an elderly gentleman in possession of two antique, inoperable firearms. And he was charged under the felon in possession because he had a prior felony from 20 or 30 years ago. And then there's another case where somebody was convicted of failing to renew his liquor license, and it was a felony. And he had the temerity to have a gun. It wasn't even carrying a gun. I mean, just having it in his house is, you can't do that if you're a convicted felon. And which brings up another issue. If you are married and your wife or husband likes to hunt or shoot trap, can they keep guns in the house? That's an issue. But anyway, as of now, the prohibition in Missouri is still in force, and the convicted felons are forbidden to have arms. And so I don't. We have quite a few of those situations in St. Louis where carrying guns even before the change in the law was pretty common. And but it's kind of like we're getting toward Dodge City, and without Wyatt Earp, and unless you think Chief Dotson is Wyatt Earp, I'm strictly nonpartisan. So
on the new law in Missouri regarding carrying concealed weapons, does that same freedom apply to carrying weapons that aren't concealed?
Yes. Yeah, oddly, Missouri law was very, open carry was never forbidden at the state level, except for, you couldn't carry your six gun into church, or there were certain areas where it was specifically forbidden. But by and large, open carry was lawful unless there was a local ordinance that restricted it. The city of St. Louis used to have an ordinance that said that you could not transport a weapon except unloaded in a locked container. And so that many concealed weapons cases I used to prosecute before I went on the bench. I was with the city councilor's office, and I used to prosecute in city courts. And if the circuit attorney didn't want to be bothered with a felony charge on a concealed weapon, they would refer it to us to prosecute under the city ordinance for the unlocked container, or the not carrying it in a locked container. So within the last few years, though, the legislature acted to annul the local regulations also. So, in my opinion, you can walk down Market Street with your 6-gun on your hip, and I think it's okay, but don't quote me to don't quote me to Judge Mullen, because he might not agree. But Missouri, there really was no statutory prohibition on open carry in Missouri, and now the concealed weapons permit, as I read the law, the effect of that to get a to go through the trouble of getting a permit. The principal advantage is that other states will recognize that, so that you can carry in if another state will recognize that permit, then you can carry in that state if you've got a Missouri permit. And then if you do have a Missouri permit, I think you can carry concealed in some areas that you otherwise would not be able to. But there too, it's a very elaborate set of statutes, and I've been, judges, among others, are authorized to carry firearms, and some of my colleagues actually did, and I'm not that good of a shot, so I felt I would be as much of a danger to myself. It's like that guy who shot himself at the Steak and Shake. That'd probably be me. So the only time I seriously considered it was a few years ago when we had this series of carjackings by this group that were just marauding through the city, and it was happening everywhere. And I thought, well, maybe I'll bring my shotgun, but I didn't do it. Yes, ma'am.
Just so I can get an understanding. So can I just go to a gun shop and just buy a gun, take it home? Just like
The question is, can you buy a gun like a loaf of bread and just take it home? To buy a gun, you still have to jump through the federal hoops of the background check and all that stuff. But assuming, you're otherwise qualified, you just go in, get it, and you can, if you want to buy the ammo in the holster, you can strap it on and walk out the door with it, in my opinion. But if I were you, I would check if you live in the county, you better check with McCullough to see if he agrees with me, because you don't want to have to, defend. Let's see, I think there was one down here and then one back there.
I'm not quite sure that I understand the difference between, I know what it means, open carry versus concealed, but what is perceived as safer for the public, or what is, I don't quite get why it's such a big deal. What's the difference?
Well, I'm not sure I'm able to answer that. As far as what's safer for the public, I suppose speaking personally, I guess I would just as soon see the gun on your hip and know that you're armed as opposed to just guessing whether you are or not. But I don't know. Years ago, when the concealed carry law was first passed, there was tremendous debate about how this is going to worsen crime, there will be more violence, et cetera, et cetera. I don't think that happened, really. The people who took the trouble to get a permit were not the ones that we really have to worry about. And, but, now with, anybody, they're off, as one of my favorite lines, I think it's from Raymond Chandler, is so many guns around town and so few brains. Yeah. And, they're a tremendous, amount of firepower out there, and I don't flip anybody off when they cut me off. Yes, ma'am.
I just wanted to say that I know for myself, being very active on issues, attending hearings and speaking out. Okay, I want to make sure.
I tend to be kind of soft-spoken, so.
Is it on?
I noticed it in that I, am an active person participating in hearings. I work on environmental issues. There's a lot of anxiety and anger in the public. And I remember at one point during a hearing thinking, I wonder how many people have a gun tonight in this room. And I think that's my big concern. And it sort of piggybacks on your last comment that cool heads is what we need. It's not necessarily the gun, but what will people do in different circumstances? And I actually know of someone who's a woman who was sort of abused by her husband, and he carried a gun, a loaded gun in his pocket, and I had no idea that he did that. And they got into an argument, and she actually hit him on the arm thinking that he was going for his pocket, and she was actually charged with spousal abuse and pled guilty to that charge in a rural county in Missouri. Because her attorney said, well, he's doing nothing wrong. Anybody in this county is probably carrying a gun. So it's really strange how we look at these issues. It might be legal, but is it really serving society, I guess is my question.
Well,
Because it actually can inhibit discussion. Because you're fearful someone's going to act out of anger toward what you're saying.
well, and I think the legislature did attempt to address that by their list of places where you're not supposed to carry. Courthouses being one. This building, I think, would be another. I'm not going to ask if anybody's packing tonight, but that's obviously a policy question, and I think I don't know, but on the other hand, the people who are in favor of the liberal approach, not in the political liberal sense, but in freewheeling sense, there is a tremendous concern in some areas of the community that you're just not safe, and the police can't be everywhere at one time. So that the argument for the ready availability of weapons for self-defense, which was something that was very persuasive to the Supreme Court in Heller on the D.C. District of Columbia. Yeah, you can have a gun, but it has to be locked up and unloaded and practically taken apart. That basically nullified the right. So, it's a very serious issue, and I think, like many things, we're going to have experience, and then maybe the legislature will see it differently in the light of experience as things go on. But I really can't I can't give you much of an answer. I just know from my perspective, in terms of the criminal docket, it's probably only going to produce a minor reduction, because the other big thing is you still can't carry guns along with your marijuana. And it's pretty frequent, I would say, in probably leaving aside the felon in possession cases, our gun cases, probably a majority of them, the defendant not only has a gun, but he also has controlled substances. And so that's still forbidden. So if you're going to carry your gun, don't carry your weed. Yes, ma'am.
You're awesome, and I'm really glad you came to our class. My first question has to do with convicted felons. What's the purpose of prison if they have to continue? I worked in employment services, and if they have to continue to live as what is this convicted felon stuff? Okay, that's one. Are there unconvicted felons?
Well, there are, but I'll tell you who they are in a minute.
Okay. So just elaborate on that in terms of when do folks stop serving their time, is a question I have. The other one is regarding this stand your ground. Is there any psychological testing that occurs to possess or to get these permits in Missouri?
Well, I'm pretty sure there is none. In fact, I know there isn't. I like to shoot trap, and I recently splurged on a shotgun, and I didn't have to be psyched in order to get it. You fill it, I mean, the background check asks you, do you suffer from a mental illness? But, there's no reliable way to check that. Although I think there was a debate in the legislature about trying to come up with some kind of a database on that. But then you run into HIPAA and all the other stuff, and, it's like, I don't know the answer. As far as convicted felons, well, there too, that's kind of a policy question. There's a big movement now. I used to do employment law, and of course, an issue now is, can the employer find out about your conviction history? And a lot of, I think the president decreed that the feds won't do that, ask that anymore. I think there's legislation pending in, what's it called, ban the box. And I know, I preside over expungements where, under Missouri law, you can get certain convictions, or not convictions, arrests expunged. And, a record check, if you've ever had the situation where you apply for a job, the employer can't get certain things, and this comes to your question about unconvicted felons. In Missouri, we have convictions, which means you were found guilty and sentenced, even if you were put on probation. That's called a suspended execution of sentence. That's a conviction. We have a suspended imposition of sentence, where you are found guilty, but you are not sentenced. That is not a conviction. And if you complete probation, that's a closed record. Only you can see it, or law enforcement. But the employers have figured it out. You go and apply for a job, and they'll say, go get me a record check. Well, you'll get the record check that shows everything, and the employer will be able to see that you were on probation for, some offense when you were, a teenager or a 20-year-old experimenting when you were in college. That's a policy question as to, what point have people paid their debt to society. The guy that I, had with the gun case, he was in his 60s. He'd had no trouble for, like 40 years. I didn't blame him. He said, I work in an area where, I've been robbed. I need a gun. I feel like I need it. And I said, well, I don't blame you. I do too, but I guess you're gonna have to carry a sword. Because, when I got the case back, he had pleaded guilty. I dismissed the case. It was reversed. When he came back, he hadn't done anything during the year and a half that this case was pending in the Supreme Court. So I put him on probation for a day, and because he was no threat to any of us, and there are people like that, how do we, deal with that? I don't know. I think there has to be a better system, where we potentially liberalize the expungement process so that people like that gentleman can get these 40-year-old convictions erased because he's been a good citizen for 40 years. Why do we keep that now? On the other hand, there are other people who are going to argue that anybody convicted of misdemeanor domestic violence, under federal law now, that you cannot possess a gun, and that can never be expunged. And so these are all policy issues that I invite you to have a heart-to-heart with your legislator about that. I have the same reaction when I talk to legislators. So. Oh, yes, ma'am. I apologize. You raised your hand earlier, and I forgot you.
I was wondering, I know there have been some tragic consequences from the police interaction with people who have mental disabilities, and I was wondering how Miranda rights are affected by people with mental disabilities.
Well, as I indicated earlier, the police really can't be expected to diagnose, who they're dealing with. And so the law is, as long as the police are not coercive in getting the defendant, the arrestee, to give up his Miranda rights, then the mental state of the arrestee is irrelevant. Now that may go to reliability of the statement, but that's for the jury. see, in the preliminary process of whether a statement comes in or not, I don't decide whether it's believable. All I decide is whether the police officers are believable when they say, yes, we gave him his warnings, and he said, yes, I'm happy to talk to you, and here's what he said. So I just, that's my role as the gatekeeper. Does it come in or not? And if I say it comes in Missouri at least, the jury is instructed, or can be instructed, you have to decide, is that statement voluntary, and do you want to give it any consideration? So in Missouri, at least, there's another protection, and I think jurors take their job very seriously. So I believe in the jury system, and so there's another protection where the jury decides, and with a gentleman, if a defendant has a mental illness, and that's apparent, and the jury's informed of that, they can take that into account in deciding, well, this guy didn't know what he was saying. But for my purposes, unless it is so bad and so apparent that the person doesn't know what he's doing, that his waiver was not intelligent. But that's the standard is it has to be voluntary, knowing, and intelligent. So there can be, a class of arrestees whose mental illness is so blatantly obvious that I would not admit the statement, even if the officers did nothing wrong, But so there is an area where that can be a factor.
Judge, we've got two more questions, one here and one behind you.
Okay, it's very very hard to see the troops behind me.
Right.
My question is have you ever had a case where somebody claimed to be defending himself and shot other people in the course of his so-called self-defense or damaged a lot of property? Would in fact that individual be then liable?
Most crimes are also what we call torts, where somebody could be liable for the conduct. To answer the first part of your question, I've had cases where the self-defense was claimed, and it's almost 9 o'clock, but I have to tell you about this case because Scott Rosenblum, any of you have heard of Scott Rosenblum? But anyway, the defendant was tried twice. The first trial was overturned. Between the murder was on videotape because these people had gotten a video camcorder for Christmas. This is going back a ways, and they were out on the street filming whatever was going on, and they filmed the murder. Well, there was a lot of fear of this particular defendant, so whether it was really him on the tape or not was disputed at trial. He was found guilty, was reversed, came back to me for a retrial. In the meantime, the state cut a deal with the co-defendant to rat out my defendant. So suddenly the defense had been, it wasn't me, I didn't do it. After the co-defendant came in, it was, well, I was there, but it was self-defense. And so he claimed he had fired in self-defense. If you do shoot somebody claiming self-defense, you can be liable in damages to that person because if you, in fact, did not have the necessary basis to use deadly force.
Well, because I was thinking in terms of, like somebody says, okay, I shot somebody because they were trying to get into my house.
Right.
And he ended up shooting people who were bystanders.
Right. Yeah.
That's what I was.
Well, yeah. An innocent bystander. Yeah, there could be a suit, and if the jury finds that the shooter was negligent, either because he didn't take careful aim or whatever, there could be liability.
And what the judge is talking about is there could be civil liability.
Civil liability.
For having shot
Damages,
innocent
like
bystanders.
an auto
Not
accident.
criminal, and that would be up to the state whether they prosecute criminally. But there's also a potential
Right.
for civil liability, which is different than.
Thank you, John. I was violating my daughter's rule. I was not clear.
And I'm going to cut the questions off, although they've been great.
Did you?
I still want the judge to feel like.
Given the people with whom you're dealing, some of these criminals, do you ever feel insecure with regard to your own safety or your family's safety?
I never have. I have been threatened once or twice. One guy, he threatened me, or he didn't threaten me directly, but it got back to me that he was making threats. He had a storied history in Missouri. He was very active in the civil rights movement, but then he turned to other enterprises. Solomon Rooks, I don't know if anybody's ever heard of him. Anyway, he threatened me, but I didn't fear him because I knew I could outrun him. He was about 75, and then I did get a threatening letter from somebody. I turned it over to the feds, and they came back, called me, and said, everybody gets letters from this guy. He's a harmless, So no, I have never felt threatened, and in fact, other than those two incidents, I don't think I've been threatened. It can happen. Judges have been killed in other jurisdictions, but the most danger for a judge is domestic.
Right, there was a shooting in this courthouse.
Well, yeah, Mr. Baumruck that was a domestic case.
And that judge was wise enough to go under his.
Well, Sam got out, Judge Hias
But his.
got out of there. But I think his bailiff was wounded.
In the shoulder.
Yeah, no, but that's where typically, defendants, unless, there have been situations where, like the drug cartels in Texas, I think, have murdered judges, but no, we've never lost a judge, and I don't think we've ever lost a juror either. So don't be. So okay, it's time.